Good evening, everyone. I'm Teddy, and you are listening to Night Talk. Disclaimer: copyright under Section 107 of the Copyright Act of 1976. Allowance is made for fair use for purposes of criticism, comment, news reporting, teaching, scholarship, and research. Fair use is a permitted statute that might otherwise be infringing for entertainment purposes only. Shout out to all my other bears I call the Grizzlies. Grab your wine and let's get ready to review the Kevin Hart, Miesha Shakes, the NDA agreement.
Let's talk about that. So the cheating, what have you witnessed besides everybody seeing the tape? What have you witnessed though, personal assistant?
I witnessed there's a blonde girl who has this pretty curly hair. She's light skinned, skinny. I think she's probably black and white, black and Spanish or something. And she has like this fluffy natural hair. And he bought her in the office, and she drives a Range Rover. That's how I know who it is. And Kevin drives his different cars. She comes into the office, and when he introduced her to me, he said that she was his model for Hustle Heart, taking the Hustle Heart supplements and, posting them.
So he got a supplement line.
Correct.
Called Hustle Heart.
I don't know if it's called Hustle Heart, but I know it's a supplement line. I don't know what it's called.
Okay.
I forget, but it's a supplement line that he has.
And she was the model.
She was the model.
Gorgeous.
She's beautiful.
Okay, what'd you see?
So
y'all better put some respect.
Don't get me America.
Y'all better put some respect on these assistants, okay?
Don't get me America.
And if my assistant sits down, y'all better take it.
Don't give me America.
Take the interview.
I'm giving
It's the best wine you'll ever get.
Y'all better get in here. All right. Listen carefully. Listen carefully. I'm just going to get right into it. At some point, I will, come out, shout out some of you. But because of the lateness of the hour and the fact that I'd like to, just get right into it, I am going to do just that and say a big blanket hello and welcome to everyone who is joining me tonight. All right. So, first of all, let me just say in general that an NDA. So, what is that? Let me just cover that real quickly. So, an NDA or non-disclosure agreement is a legal contract between two or more parties that outlines the confidential information they wish to share with one another for certain purposes, but want to restrict from being disclosed to third parties. The primary purpose of an NDA is to protect sensitive information and trade secrets. Some of the key components of an NDA typically include parties involved, the identities, the individuals or entities entering into the agreement, often referred to as the disclosing party and the receiving party. Also, the definition of confidential information clearly defines what constitutes confidential information under the agreement. This can include a wide range of information such as business plans, trade secrets, financial data, technology, and or other proprietary information. Let me just make sure the mic is open. We'll take this off. Let me know that the sound is good. All right. By giving a quick thumbs up so that I can continue. All right. The purpose of disclosure specifies the reason for sharing the confidential information. This should be related to a potential business, collaboration, partnership, employment, and or any other specific purpose. Obligations of a receiving party outlines the responsibilities and restrictions imposed on the receiving party concerning the use and protection of the confidential information. It may include clauses specifically that the information should not be disclosed, duplicated, or used for any purpose other than the agreed upon purpose. The duration of confidentiality defines the duration for which the confidentiality obligations will last. Some NDAs are time limited, while others may continue for as long as the information remains confidential. Exclusions from confidential information specifies certain types of information that are not considered confidential and therefore not subject to the restrictions of the agreement. Here's something that's key in the complaint, and it's breach of contract. Well, part of an NDA, the consequences of breach typically are outlined, and the potential legal consequences if the receiving party breaches the terms of the NDA. This may include damages, injunctive relief, or other remedies. And then finally, governing law and jurisdiction, which would indicate that the jurisdiction and the laws that will govern the agreement in the case of legal disputes. So then, NDAs are commonly used in various business transactions, collaborations, employment relationships, and any situation where one party needs to share confidential information with another while maintaining control over its use and dissemination. So let's take a look more specifically at the agreement. And let's just pull it up right here. Do it like that. And I will go over it. But just before I do, hang on. Hang on. Thank you, Vicky Black says. Sound is good. Hang on. You know what? I can tell that we have many more in the bushes than we do in the chat, and that's just fine. If you have a comment that you would rather not put in the chat, you can email me at unwinewithteddy@gmail.com. Okay? So let's begin. Mutual release and non-disclosure agreement. This agreement affects your rights. Read carefully before signing. This mutual release and non-disclosure agreement, or the agreement, is entered into between Kevin Hart, K. Hart Enterprises Incorporated, Heartbeat Productions LLC, Heartbeat Digital LLC, and all other affiliated and related entities owned and or controlled by Kevin Hart, collectively Hart. On the other hand, and Miesha Shakes, on the other hand, Hart and Shakes shall collectively be referred to herein as the parties, and each individually as a party. The parties agree as follows. In consideration for Hart arranging to provide 1. Health insurance coverage to Shakes for a period of 36 months. 2. A severance payment of $30,000 per year for a period of 3 years. And 3. Other good and valuable considerations, including but not limited to the mutual release of claims, the receipt and sufficiency of which are hereby acknowledged. So you might wonder what all of that means, okay? And I did a little bit, a little more research so that I could at least give maybe a better analysis of what some of that might mean. So, in that first part, this mutual release and non-disclosure agreement, it's between Kevin Hart and affiliated entities referred to as Hart and Miesha Shakes. The agreement outlines that in exchange for certain considerations, including health insurance coverage. So he offers, or I will say in this agreement, there's insurance coverage, 36 months, and an annual severance pay for the 3 years as other valuable considerations for the parties released in a mutually release any claims against each other. So when we've looked at what was in the complaint and what, let's just say, Hart and his attorneys were looking for to recover that payment, at least in that amount, that $90,000. All right. The parties, Kevin Hart, Miesha, are collectively referred to as parties. So let's go one by one. Protection of confidential information. Number one. 1.1 Definition of confidential information. Confidential information means all of the following, whether intangible or tangible, read, heard, observed, or contained in or comprised of documents, electronic data, emails, instant, direct, or text messages, moving or still images, sounds or audio recordings, or any other recorded medium or format of embodying information or data, whether it's truthful or fictionalized, and whether learned or obtained before, on, or after this agreement's date. 1.1.1 Private and confidential information which is not generally known to the public or readily ascertainable by proper means by others and is subject to reasonable efforts to affiliate it or maintain its secrecy pertaining to any of the following protected parties: Kevin Hart, his affiliated companies, which are K Hart Enterprises Incorporated, Heartbeat Productions LLC, Heartbeat Digital LLC, including their officers, directors, and executives, and Kevin Hart's family members, past, present, and future, and their affiliated entities, including their officers, directors, and executives. Point two, underneath 1.1.12. Protected parties, proprietary business information, financial or legal matters, actual or potential business or entertainment projects, whether or not produced or completed, creative processes, production methods, and trade secrets, means information held in confidence which has economic value, actual or potential, from not being generally known to and not being readily ascertainable by proper means by others. Next one. Protected parties, private or personal conduct written or verbal communications, including but not limited to text messages, emails, voicemails, family and home life, or family and communications, including but not limited to text messages, emails, voicemails, family and home life, health, medical, and sexual information, leisure activities, customs, proclivities, private contact information, security alarm codes, and schedules, itineraries, and in point 4 under the same, this agreement, its negotiations, and its term. Plural. 1.2. Agreement not to disclose or use confidential information. Hang on. Shakes shall not directly or indirectly disclose, exploit, or disseminate confidential information to any person or entity whatsoever, including but not limited to friends, family members, journalists, tabloids, television or radio programs, websites or internet social media, i.e., Facebook, Twitter, Instagram, TikTok, Snapchat, etc., all collectively third parties, or threaten to do so. This applies to all confidential information, whether truthful, fictionalized, on the record, or off the record. Without limiting the foregoing, Shakes specifically agrees not to give any interviews about the protected parties or confidential information. This is under the agreement not to disclose. Confidential information shall continue to be subject to this agreement even if it is wrongfully disclosed by Shakes or by third parties. Non-disclosure agreement. Good evening. Let me LaDonna Brooks says, sounds like every base is covered. You would think, says Lisa, it would be a good job for a PA, but they do so much I would have to pillow talk just a little bit. What are you talking about? 1.3, no use of name or likeness. That means, or it's stated, Shakes shall not directly or indirectly exploit the names, likeness, and or identities of the protected parties to promote, advertise, endorse, or market any services or products of any kind or nature without Hart's advance written consent. 1.4, no images and recordings. Shakes shall not directly or indirectly create, transfer, duplicate, or retain any photographs, moving or still images, sound recordings, or otherwise capture depictions or likeness of any of the protected parties or protected parties' workplaces, residential locations, or of any confidential information, images and recordings, all images and recordings directly or indirectly created or retained by Shakes, whether in breach of this contract or at any protected party's direction or otherwise, shall be Hart's sole and exclusive property and constitute confidential information in which Shakes has no legal rights or interests whatsoever, including any copyright, trademark, moral rights, or other similar rights, and Shakes conveys, transfers, and assigns to Hart all of her rights, title, and interests, if any, of whatever kind of or nature in all images and recordings as their creation and in perpetuity throughout the world. And this agreement shall constitute a valid transfer of copyright. A lot of legal wrangling there, or words. But it does say at the top, this agreement affects your rights. Read carefully before signing. And not only that, it's recommended, highly recommended, before signing agreements, NDAs, that you consult with a lawyer, not just an advisor, but if you have, the money and you're really entering into this is a business agreement, it's legal, binding, to consult with an attorney. 1.5, permitted disclosures responding to subpoenas. Shakes may disclose confidential information in confidence and pursuant to legal privilege to her attorneys as required for the rendition of their professional services or as is otherwise required by law. If Shakes is compelled to disclose confidential information pursuant to valid legal process, i.e. subpoena, she shall first provide Hart with reasonable advance written notice pursuant to this agreement's notice provision. Shakes shall not volunteer to disclose confidential information. 2, remedies for breach. If Shakes breaches this agreement or threatens to do so, that would be by conduct by Shakes reflecting an intention to breach, she shall be liable to Hart for all resulting damages, including but not limited to all of the following, all of which shall be cumulative to be sought pursuant to this agreement's mandatory arbitration provisions. 2.1, liquidated damages. Shakes' actual or threatened breach of this agreement shall cause Hart substantial damages and injury, the precise amount of which would be extremely difficult or impracticable to determine even after the parties have made a reasonable attempt to do so. Shakes therefore agrees that in addition to Hart's other remedies, Shakes will be obligated to pay Hart the sum of $50,000 as a reasonable and fair amount of liquidated damages to compensate Hart for loss or damage resulting from each actual or threatened breach. Now, let me just make sure here. It says this fair amount from each. I have to think about that. The way it seems to read, I'm not sure if that would mean $50,000 damage for each or actual breach. I'll continue and then try to get an answer specifically. The parties agree that this sum bears a reasonable and proximate relationship to the actual damages Hart will suffer from each actual or threatened breach, and that is not a penalty. Alternatively, Hart shall have the right to seek actual damages according to proof instead of liquidated damages. 2.2, disgorgement of ill-gotten gains. Shakes, actual or threatened breach, will obligate her to account to Hart and turn over to Hart all monies, considerations, profits, or other benefits Shakes derives from her breach without prejudice to Hart, other legal or equitable rights or remedies. Injunctive relief. 2.3. Since Shakes' actual or threatened breach will cause Hart irreparable injury, which cannot be adequately compensated by money damages, Hart shall be entitled to obtain temporary, preliminary, and permanent injunctive relief to prevent Shakes' breach or further breach injunctive relief. The balance of potential harm to Shakes arising from injunctive relief is substantially outweighed by the substantial harm to Hart resulting from unauthorized dissemination or exploitation of confidential information. So now, if I was getting ready to sign something like this and just carefully reading it, that wouldn't be enough at all. I mean, you can just imagine each of these items and what the ambiguity might be inside of them, or one's interpretation of the meaning of each of these bullet points. 2.4, attorney's fees and costs. In any proceeding arising out of or related to this agreement or its enforcement, the prevailing parties shall be entitled to recover all of his, her, its reasonable attorney's fees, costs, and expenses incurred. Let me put up this banner. Fair use commentary. What do you think so far? I think on its face, it's going to be difficult, perhaps, to overcome what's laid out so far in this agreement. However, it's really going to depend on a number of things that I've been looking into. Once again, the ambiguity of this contract, how written, could be a sticking point. Could be. 3, mandatory confidential binding arbitration of disputes. So the parties agree that the exclusive manner of resolving any and all future disputes between them of any kind or nature whatsoever, including but not limited to disputes regarding validity, interpretation, enforcement, or claim breach of this agreement, shall be solely by mandatory binding confidential arbitration. Arbitration shall be administered by JAMS under JAMS comprehensive arbitration rules and procedures. And there is the website for that in Los Angeles, California. It says heard and decided by one neutral arbitrator selected by mutual agreement or JAMS rules. The parties have the right to conduct discovery in accordance with California Code Civil Procedure 1283. And discovery requests and results shall be deemed confidential information. Whether a dispute is subject to arbitration and issues regarding jurisdiction and enforceability of this agreement shall be determined solely by the arbitrator and not by any court. The arbitrator may impose any and all legal and equitable remedies that would be available to any party before governmental dispute resolution forum or court of competent jurisdiction. Arbitration will not apply to any claims necessarily excluded by law. The prevailing party shall be entitled to recover all reasonable attorney's fees, costs, and expenses incurred to the greatest extent permitted by law. Any papers required to be delivered or served in connection with arbitration may be sent via this agreement's notice provision. The arbitrator shall issue a written opinion containing his or her factual and legal reasoning. If the prevailing party files a petition to confirm the arbitrator's award, and or if any party seeks to vacate an award, any documents filed with any court containing confidential information shall be filed under seal to the greatest extent permitted by law in order to maintain confidentiality of confidential information. Who wrote this? Who wrote this? Well, I think at least one lawyer was involved, or two. By agreeing to arbitration, the parties are giving up any right they may have to a trial by judge or jury regarding matters required to be arbitrated. The parties understand, acknowledge, and agree that there is no right to an appeal or a review of an arbitrator's award as there would be of a judge or jury's decision. Who would then, I'm just pausing. Who would want arbitration with these parameters? These are restrictions. Because it's up to one person if you're going to have arbitration on what you agree to be arbitrated, I guess. The case. Four, mutual release, except for the obligations arising from this agreement. The parties, on behalf of themselves and their heirs, hereby irrevocably, unconditionally, and completely release, discharge, and hold each other and each of their current and former agents, employees, representatives, assigns, predecessors, successors, principals, partners, attorneys, managers, publicity representatives, and insurers, including the protected parties, and each of them collectively, the releasees, harmless from any and all claims, liabilities, suits, causes of action, demands, damages, debts, obligations, controversies, costs, expenses, and judgments of every kind or character arising in law or equity under contract, tort, governmental regulation, state or federal law, or statute that the parties ever had, now have, or hereafter may have against the releasees throughout the world, based upon or by reason of, in whole or in part, any act or omission to act. You might say, why aren't you pausing? I'm trying. It's comma after comma after comma. I have never seen so many as one sentence, but in this agreement. I mean, really. Throughout the world, comma, based upon or by reason of, in whole or in part, any act or omission to act, transaction, practice, or conduct, whether known or unknown, suspected or unsuspected, foreseen or unforeseen, arising or existing at any time before the execution of this agreement, the released claims, period. Finally, a period. The parties forever waive and relinquish as to the release claims, the provisions, rights, and benefits, if any, of California Civil Code Section 1542, and all rights and benefits under similar law of any other jurisdiction to the fullest extent that they can be waived. California Civil Code Section 1542, or I say 1542, provides a general release does not, and it's bolded, it's capped, all caps, a general release does not extend to claims that the creditor or releasing party does not know or suspect to exist in his or her favor at the time of executing the release, and that, if known by him or her, would have materially affected his or her settlement with the debtor or released party. Now, any of you Wouldn't you want this all explained by a lawyer? Even if it is $400 an hour, $500 an hour, because to sign this, and in this case, let me just pause. Miss Shakes is saying that, I'll just say allegedly, that it appears to be, I should say that, appears to be loopholes that have been found in this agreement or contract. And it can severely cost, a lot of money, according to what is written in this contract, if it's found, breach of contract and that. Five, miscellaneous governing law. This agreement shall be governed and construed in accordance with California law, and the parties agree to submit to the jurisdiction in the state of California, County of Los Angeles, to resolve any dispute relating to or arising from this agreement. So then, if it's going to be in California, that is most likely going to mean that those who want to see the trial, if it goes to that point, it's going to be in California. Yeah. Well, it's a big state. Let's see. No waiver. This constitutes the entire agreement between parties pertaining to its subject matter, and there are no terms other than those it contains. No supplement, modification, waiver, or termination shall be valid unless executed in writing after the date hereof. Severability. If any provisions is invalid or unenforceable, the remainder will continue to be valid and performed, construed, and enforced to the fullest extent permitted by law, in accordance with the parties' intent as determined from the face of this agreement. No implied promises. The party or parties have not made any promises or inducements to persuade one another to execute this agreement other than its express terms. Successors assigns third-party beneficiaries. This agreement ensures to the benefit of and is binding upon the parties' respective heirs, representatives, executors, administrators, successors, trustees in bankruptcies, and assigns protected parties are intended third-party beneficiaries of this agreement with the right to enforce its terms. Attorney's fees if any proceeding is brought to enforce or interpret this agreement, or the rights or obligations of any parties. Now, you could certainly read this if you're having difficulty sleeping. try reading this 3 times, including reliance on this agreement as an affirmative defense. The prevailing party shall be entitled to recover as an element of such party's costs or suit, and not as damages, all reasonable attorney's fees, costs, and expenses incurred. We're almost to the bottom. Notices. Any notice may be sent or served in writing by personal delivery, email, or prepaid overnight delivery service, such as FedEx, sent to Shakes at her address listed below, and to Hart, care of Andrew Bretler, and it gives the address there in California. Knowing and voluntary agreement. Shakes expressly acknowledges reading this agreement and understanding its terms, and that Shakes is entering into it freely and voluntarily, and either consulted with an attorney before signing this agreement or had the opportunity to do so, but voluntarily relinquished that right. Execution. This agreement may be executed in separate counterparts, each of which, when so executed, shall together constitute and be one and the same instrument. A fax, electronic, and or PDF signature or other copy signed counterpart shall be deemed original and have the same force and effect as signed original. Understood, accepted, and agreed. You can see the signature on the left of Miss Miesha Shakes, and there on the right, DocuSign Kevin Hart on behalf of himself, the protected parties, and all affiliated entities referenced herein. It's dated October 22nd, 2020. Hers is dated, and there you see it. The interpretation, I actually have some of that, or at least part of the analysis of this, which I may, let's see, it's 11:30. Let me come out, take a look at the chat, say hello, and just say that the seriousness of this case is not to be it's not to be taken lightly. I mean, there will be some levity to be made, but all in all, in the court, if this goes to trial, it could get rather nasty, someone has said. Could get. Or it could be settled out of court. It could be. Let me come out. It's a lot to it. A lot to it. Let's just see something else here. Looking at the text of that NDA, the legal document is highly nuanced. Highly. Whether or not it's parts of it can be determined to be very ambiguous. It's to be determined by those legal experts who will certainly go through it line by line. I'm sure of it. However, based on some of the text provided and some of the things that I've looked into, certain general considerations that parties often, what they say, scrutinize for potential issues in an NDA is the specificity of confidential information. So that might appear like the agreement should clearly define what constitutes confidential information to avoid ambiguity or disputes about the scope of protected information. Well, there was one part that I read from this morning that covered confidential information, and it seemed to be vast and cover so much, almost as if when I've read it and looked at it, how could one, I should say, get around it? And then in this arbitration clause, it says, while arbitration is common in a dispute resolution, the effectiveness can depend on the fairness of the arbitration process. So there are some potential limitations or one can think of biases that might come out during that arbitration. Then the release language. It's said should be clear and unambiguous. Ambiguities in the release section often leave room for interpretation and potential disputes. Then there's the California Civil Code, Section 1542 waiver. That's a very important part of what I've read from. So while the agreement acknowledges California Civil Code, Section 1542, specific legal circumstances, it said, could impact the effectiveness of such a waiver. So that parties should make sure that they understand the implications, fully understand. And then there's what is called a notice provision. So clarity in a notice provision is crucial to ensure effective communication between the parties. Ambiguities or impractical notice methods may create potential issues. So that it is crucial for both parties, and I've read it at the end of this, to have legal representation during the drafting and review such agreements to ensure that, quote unquote, their interests are adequately protected. That's one of the statements that was made by Miesha. protection. Protection for whom, though? Their interests, her interest, because she mentions it in conversation with Tasha K. You know, when asked, why is she talking about this? Why is she? I also looked into some information regarding if a person who signed the agreement discloses information to someone such as a blogger who would interview them. So if a person who signed, it said, a mutual release and non-disclosure agreement discloses, this kind of information during an interview, it said that it could potentially constitute a breach of the confidentiality provisions outlined in the agreement, and that the specific language and terms of the agreement would be crucial in determining the extent of the breach and legal consequences. So once again, when we read through or listened to, I read, in the complaint and confidentiality agreement, it included as part of the complaint information that was disclosed and then further disseminated by Tasha K, the blogger. But once again, it has not been, both sides haven't been heard. It's very early in the process, and we just have to wait to see how it unfolds. But there's a lot of considerations. And Giabapaya says, how many pages are there in this complaint, including the addendums or the, let's see, let me look here. All of those A, B, and C exhibits, 21. It's all about the wording. Yeah. Yeah. A lot to digest. A lot to think about. Even as someone who is just, looking from the outside, looking in. There's a lot. So a lot's going to be said. People are going to be making, judgments against what Miss Shakes said, the judgment, her judgment, Tasha K's judgment, and so forth. We don't know. It's not over, right? It's still early on. They haven't even chosen, it hasn't even been determined if it's going to trial. But as it unfolds, I will continue to cover it as new documents come in and I can get a hold of them. I will either read them in part or in whole, depending on what it is. But I certainly wanted to read the entire complaint or the complaint in its entirety. Okay? And we did just that right here on Unwine with Teddy. Now, in the beginning of this broadcast, you may have noticed, if you were here, I played a short clip from the interview. That was broadcast on December 22nd. Yeah. I hope to play more and give commentary. Okay. So now I'm going to read just a few more of your comments, and then we're probably going to wrap this up for tonight. It's Friday. It is Friday. 2 more days in the year. 2023 is just about done. Don't get the time back. What a year it has been, but it's not over yet. Still don't know things. There could be more breaking news that could come out, overnight. We just never know, in the world that we live in, what might happen. There's a lot going on. So as you, gather with your friends, your family, your loved ones this weekend and prepare to ring in the new year, I hope that it's a safe one, that you get to your destinations. Yeah. LaDonna Brooks says the use of commas were a big help. Time to take a breath. Yes. Legal jargon wasn't too obnoxious. They made it easy to read. Yeah, I could get through it. I may have stumbled over 1 or 2 words. I'm just exaggerating a few. Not too many to cover that amount of reading. But it was a lot. 2024 is right at our door. Let's see. Well, at least Kevin will have comedy content. You think? Do you think he'll be able to laugh at himself? Yeah. Hashtag make YouTube fun again. Haven't seen that hashtag in some time. Water break. I need a big one. I'm looking over your comments. Now, I should do this. Check the mail. Check the email. Let's see what's out there. And shout out to Instagram, Facebook, hanging out with us tonight at this hour of the night. I'll be right back.
지난 추억들의 사랑을 더해 Let me have you pull me closer 너의 곁에 지켜줄게 You My love 어둠이 다가와도 괜찮아 내 널 가득 안아둘래 바다와 같은 너의 눈을 보면서 우리 둘만의 사랑 고백 온 세상에 살구빛이 먼저 I smile 소중한 것만 몰라 전부 주고 싶어 너에게 Let me have you pull me closer 기다려 순간이야 You My love 눈물이 난대도 괜찮아 내 널 가득 안아둘래 바다와 같은 너의 눈을 보면서 우리 둘만의 사랑 고백 아직 많이 서투지만 바다와 같이 사랑하고 있다는 걸 깊은 나의 마음 안아줄래 그대 따뜻하게 날 감싸주네요 그대 마음도 나와 같네요 내 널 가득 안아둘래 바다와 같은 너의 눈을 보면서 우리 둘만의 사랑 고백 매일매일 너와 함께 할래 바다와 같은 너의 꿈을 안겨서 Dear my ocean
All right, so we're good for tonight. Biggest bear hugs go out to all the Grizzlies. Once more, thank you so much for joining me tonight. This is the last Friday in the year of 2023. How we would spend our Friday night just like this. Who knew? But I'm glad that I'm with you. I am. Yeah. If there was something you wanted to say, but you didn't get a chance to be heard, email us at unwinewithteddy@gmail.com. But now it's time to say goodnight. Yeah. Hope that each and every one of you have a good night. Thanks for watching. Until next time, I'm Teddy. Good night. You did hear that, right? Good night. I couldn't resist coming back to read that comment that you just made, Vicky Black. Teddy, we went through a lot this year, but we made it through here in the Bear Cave. We went through a lot. A lot. A lot. I agree. Well, I have to do, like some stations are doing, the year in review. What would the year in review look like? Well, I have it all. I could do something like that maybe. But it has gone by. Yeah. That's real, says Zenobia. It's real. It is. What will 2024 bring us? Yeah. Exposure. That's what's happening. That's the word. That's the word it seems to be. Okay. So thanks for saying that and reminding us, Vicky Black. But we're here. Right now, we're here.